Well, joining us to speak a little bit more about these developments, we're joined by Advocate Mkhwebane's fitness to hold office. We're joined now by legal expert Advocate Molatelo Mahapa. A very good evening to you, and thank you so much for speaking to us. So, as you've seen and heard there, a majority, if it were, of the committee has resolved that Mr. Dali and Mileham's not recusing themselves is acceptable, except, of course, you've heard from the EFF's objections. Your thoughts on these 12 points that were ventilated? They were referred to as generalized by the chair, and as you heard from Mr. Mileham's as well, that there was no evidence of them being biased. Your thoughts on that?
Thank you very much, and good evening to the viewers at home. Indeed, I've heard, how the chairperson articulated, his views on the points, and I firmly believe that, he held a strong view, and he has a right to his, obviously, decision. And if there's any party that maybe objects to that, maybe they should be afforded, an opportunity to even proceed, with their appeal process, if any.
As you say that there was independent legal opinion, just share with us the role of and how it's chosen, that legal opinion that is said to be independent, because some were questioning the independence thereof. Some were saying, why didn't you use this legal advice, etc., etc. So how important is that, whether somebody has presided over a matter that involved another party that may have been seen as, just take us through that, the process.
It is very critical or very important for one to, when making their own opinion in this regard, I'm referring to this matter in particular, that definitely they need to be, not biased. They need not to even have conflict of interest. But in this case, in relation to the advocate, remember that legal representatives or advocates or attorneys, they serve quite a number of clients, as long as it is clear that there is no conflict, in terms of the role that he played, if for instance he was involved in this particular matter at some point or the other, then I would seriously, consider that as having conflict, So you can't just barely, make or suggest that there's conflict without proof and showing evidence to that effect.
All right. Thanks for explaining that to us, the issue of impartiality. Now, the EFF MP Kevin, for instance, complained that she received Dali's submission an hour into the meeting. We know that the whole matter was put to a vote, and she said the majority vote does not necessarily mean that the majority is correct. Now, we've seen it at the Constitutional Court, where the whole concept of majority vote, even though a minority vote is acknowledged. In a situation like this, how does it compare, and does it speak to a general consensus that this is the right way to go?
Yes, I fully agree that this is the right way to go. And indeed, yes, there are times where you'd have majority deciding on a particular matter, but when you actually evaluate maybe constitutionality or legalities thereof, and find that they are not necessarily correct, It's important to afford all parties, a fair chance, whether minority or, the majority.
Okay. So the Freedom Front Plus MP Kone Mulder, for instance, was saying that Advocate Mkhwebane and Mpofu aren't the only people with rights, and Parliament also has rights. Just sticking with that concept of majority versus minority in terms of rights. So, I mean, even societally, this argument has been had about whether the majority's rights supersedes the minorities, and doesn't that deny the rights of the minority? So in this case, the recusal application of Advocate Mkhwebane was accusing Mr. Dankie of being hostile to her and her team, not treating them with the patience with which they believe they ought to be treated, particularly the evidence leaders, and the same was said of the DA. How do we weigh that up against each other?
Okay, maybe it's imperative for me to, because I know previously this question was asked, but because of time, I couldn't, assist in that regard. For the public, maybe to weigh or be in a position to, get to know whether there was biasness. For instance, if the chairperson relies on, let's say, unsupported or unsubstantiated claims, or heavily opinionated or one-sided, or presenting highly, selected facts, leaving, or leaning to a certain outcome, for instance, or pretend to present facts but offers only opinion, or, use inappropriate language, or at times when, the requests for postponements are required, the chairperson would unreasonably refuse. Those are some of the issues that when we look into biasness, we really, base our facts on in terms of biasness. So in this case, I still maintain the rights of the minority are still, important. If, for instance, the majority decided on a particular fact, and the minority still has, a solid base, or let's say in relation to what I've mentioned, those facts are there and the evidence is there. The minority might have, a leg to stand on.
Well, thank you so much for speaking to us. Much appreciated. Advocate Molatelo Mahapa is a legal expert. Now, of course, as mentioned there by the chair of the committee, they've said that the committee secretary herself, the letters about the evidence leader, Advocate Nazrim Bawa's SC's recusal, that letter will be referred to her.